Welcome back. In another development, the trial of the detained leader of the proscribed Indigenous People of Biafra, Nnamdi Kanu, took a new turn after he sacked the entire legal team representing him in his case before the Federal High Court. Now, while in court, Kanu's lead counsel, Kanu Agabi's SAN, applied to withdraw from the legal representation, informing the court that the defendant had taken the case back from them. Kanu also told the court that he would henceforth defend himself in court till further notice. I still have with me Justice Ojeno and, of course, Ibrahim Garba. Well, Ibrahim Garba, before I come to you, let me quickly take up my legal championing right here. Should a defendant, rather, in a terrorism trial be allowed to represent themselves given the legal complexities involved? I really need you to, I need you to go all the way with this because I've been waiting for you.
Okay.
Right.
And thank you. The thing is, there is no distinguishing which cases a defendant can actually pick his own lawyer from. And one of the major cases, locus classicus, if I may use that term, when it comes to a defendant choosing his lawyer and the right to choose his lawyer, is the famous case of Awolowo and Shagari. It's one of the cases they will teach a year 2 students.
Before you continue, now, what do you think would have transpired that made Nnamdi Kanu dissolve his legal team? What exactly? Because I thought they were doing great. I thought they were making progress. What do you think could have been running through the mind of Nnamdi Kanu to have made such a move? Is this move calculated, or is there something we're not knowing, please? Okay,
for me, let me just first
digress
say that
a bit.
I don't have the gift of clairvoyance, so I will not be able to say exactly what happened. With his lawyering, I've seen the A team all the while. I've seen Chief Michael Zekome, SAN, also be part of the team, and of course at some point was relieved of his representation. And now Kanu Agabi is as big as it can be. I think there was also another senior advocate of the Eastern Extraction that also withdrew his services with respect in the last time the matter came up. So Kanu Agabi has been an excellent, he's one of the greatest ancestors that we have in legal practice. So I feel that for him to have withdrawn, maybe I would not have even stood a chance in the farthest part of hell to have.
So you think Kanu Agabi knows something we don't know?
No, he must have been at Nnamdi Kanu's request. So I don't necessarily think that it is Kanu Agabi that would have
made such a decision.
It must be, maybe Nnamdi Kanu requested it, or Nnamdi Kanu gave him a condition
to continue.
That made him have no choice
but to
withdraw his services. So that's on that. But on the issue of whether a defendant has a right to withdraw, to make the choice of, to represent himself, yes, it's a choice. And when we are talking about rules of procedure when it comes to court, and sometimes even that are stipulated by not just civil procedural rules or criminal procedural rules, but the constitutional criminal procedural rules, we know that the defendant has a right to choose his own lawyer. But the restriction is that the lawyer of your choosing must be a person that is qualified to practice in Nigeria. And I commend it to the issue that happened between Mr. Awolowo at the time, the sage, that tried to bring a certain barrister Gratian from the UK to come and represent him in a Nigerian case. And
that was not allowed.
And the court said, no, you cannot bring, you have a right to choose a lawyer of your choice, but the person has to be licensed to practice in Nigeria.
Okay. All right, Ibrahim Garba, very quickly, I think I need to take you up on this quickly. Does Kanu's self-defense risk inflaming political tensions or ethnic sentiments in the country, from your standpoint?
I don't think so, Mark. If I have my way, I would have maybe advised Kanu on how best to go about it, because in the first place, what were the charges against Nnamdi Kanu? It's just he declared himself, an enemy of the state, and in that manner, when he was arrested and brought in to face these charges, all what I've expected from Nnamdi Kanu is to be calm. Let the law, let the case run its full course. By now, maybe he would have been sentenced or whatever. And at that level, he might be considered for, presidential pardon and all that. But in as much as you are in detention, you are coming to the court, and you did not show any sign of or slowing down or remorse, you are making it more complicated for yourself, because this is a court of law. And all of a sudden you say, okay, you are taking your decision to sack your judges or not. How would this lead to a political solution? The case is before the court. Mr. President cannot even come into the matter, or the state governors. Attempts have been made in the past for this case to be handled amicably, but so long as this case is in the court and it does not be determined, the full course of the law, the case has not been concluded, there's no way we can even take a step further for a political solution. Okay. So it's a dicey situation for Kanu, and I would love Kanu to calm down so that let's see what happens at the end of the day, whether it's going to be charged or sentenced or whatever. Then people will can plead for mercy.
All right.
Comment on something that Mr. Garba just said.
Quickly, yeah.
Because it's very important for me to make that clarification because I'm a lawyer.
Yeah.
There is a certain case called the case of Ilorian State, and I also commented the case of Ezomo and A.G. Bendel State. In those cases, the powers of the Attorney General, pursuant to Section 174 of our Constitution, for what we call nullified prosecution, was examined, and with respect to matters that are in court, the Attorney General, the President can actually instruct the Attorney General, Mr. Lateef Fagbemi, to discontinue the suit. So as it stands, there can still be some form of political interference for the matter to be terminated at this stage. So we do not have to wait till the matter is decided by court. So when the matter is before going to court, while the matter is commencing and while the matter is continuing, before it terminates, the Attorney General has the power to quell it, to kill it. But when the matter has been concluded by a court, then the President has the power to quell it if it's a federal offense. So that's why I always say that when it comes to criminal matters, even the Supreme Court is not the be-all and end-all. The President is the be-all and end-all of every crime, even while committed, while it's being prosecuted, even after the end of it, because he also has control over the Attorney General. Okay,
well, I'm glad you're really giving elaborate explanation, because the last time we spoke about this, you said, look, the case is still in court, you don't have the power to go all the way.
Yes, we are not talking about the substance of the matter. We are talking about matters that are not the substance.
I'm happy. That's what I'm trying to say.
So if you come back to the substance, my reaction will be
you withdraw.
I will withdraw.
All right, our final